Welcome everybody to yet another Rockefeller College Lunch and Learn event. Thank you to our Rockefeller College staff, especially to Renee Wallingford for getting this all set up. And the topic for today is a look back at the 2024-2025 U.S. Supreme Court term. We have today myself and my colleague Matt Ingram to talk about what has happened on the court since the term kicked off last year. I was going to say last October, but there's a little wrinkle there that we'll be discussing. But in any event, our usual rules will prevail. We're going to give short presentations, and then we will open up the floor to questions. You can either raise your hand or you can put your question in the chat. If there is anything that you would like to ask anonymously, we can certainly accommodate that. Just send me an individual message and I will read your question without attaching your name. So with no further ado, I will turn things over to my wonderful colleague, Matt Ingram, to get us started.
Sorry, can everybody hear me now? Did I mute myself?
Good, we can hear you.
Great. Thank you, Julie. Hi, everyone. I thought I had unmuted myself, but then it looked like I was still on mute. But hello, my name is Matt Ingram. I'm an associate professor in the Department of Political Science. And I just wanted to take a step back and kind of look at what's going on at the Supreme Court from a broader perspective, sort of the Supreme Court in larger context. I know we're looking back at what's happened over this last term at the Supreme Court. But as I was thinking about this event today, I was thinking about how important it is to understand the current term of the Supreme Court in a larger context of what's happening. So in the spirit of not focusing on technical aspects of an individual case or an individual interpretation of a law or an individual justice or single specific events like that, I was trying to step back and take a broader view of what's happening in the legal political, from a legal political context. So in that sense, there is a lot happening. It's hard to keep track of everything that's going on. Just at the outset here, before we started, Professor Novkov and I were commenting on how much is going on, and it's easy to feel overwhelmed. I might come back to this later, but it's important to note that this sense of being overwhelmed is in part by design. Kim Lane Shepely, a sociologist at Princeton University, emphasizes that it's a common practice among authoritarians in countries like Hungary to deliberately distract the public and the press with outlandish acts, outlandish sort of attention-getting behavior, and then take advantage of that distraction to take more substantive actions to change the structure of government, pass laws that concentrate power, and allow the administration to do what it wants. So it's important in a way to recognize that this is by design, or at least part of it is by design, not to get distracted by those multiple shiny objects that are in the news, like renaming the Gulf of Mexico the Gulf of America, or annexing Canada and making it a 51st state, or releasing thousands of documents this weekend about MLK in the middle of the resurgence of the Epstein scandal. In this larger context, it's also important to recognize that there are much larger implications at stake based on what the court is doing for the nature of democracy and the rule of law in our country. In short, there's lots to talk about. Any one of these topics: the nature of democracy, the rule of law, authoritarian patterns outside of the United States, comparative perspectives on judicial behavior, could take up multiple hours of discussion. So I'm trying to focus on what's going on and refocus this this larger perspective that I have in mind on what's happening at the Supreme Court. So in that spirit, looking back, I think it's important to start by looking back at last year, right? Thinking about the Supreme Court in this larger context and looking back at the current term, I think it's important to take that extra step and look back at the last term first. So court watchers are used to naming the Supreme Court terms by the October in which the term starts. So the term that just ended is October term 2024. That's because the term started in the first Monday of October of 2024. So by asking us to look back at last year, I'm asking us to look back at October term 2023, the term that started the first Monday of October in 2023. That term ended with a massive victory for President Trump, then candidate for the upcoming election in 2024. The case that granted that massive victory to President Trump was Trump versus United States, in which the majority of the Supreme Court granted him almost total immunity. While the decision was couched around language about core powers of the president, core executive functions, it effectively granted him near total immunity, right? Or granted the president near total immunity. In practice, it also erased multiple pending state and federal prosecutions, principally the federal prosecutions. Including or perhaps the most important of which was the prosecution for hiding classified materials at Mar-a-Lago. In short, that decision granted a massive expansion of executive power, and specifically gave President Trump a pass, right? But it effectively makes the president nearly untouchable. Even if the president makes really bad mistakes or is engaged in outright illegal conduct, it's not an issue if arguably within a sphere of presidential responsibilities. So if we're being generous at the end of October term 2023, the opinion could be read as somewhat neutral, right? Since it could have been Biden or Harris who won the next election, it could have been a sequence of non-Republican candidates who won the future elections. So from a very generous perspective, you could say that the court was relatively neutral because they didn't know who the next president would be. However, in context, right, recognizing that the decision basically erased multiple legal obstacles to then candidate Trump, it was a very favorable decision to Trump, clearing several prosecutions out of the way of his campaign. There's a strong argument that Trump would not have won in 2024 but for that decision in Trump versus US. Fast forwarding then from that decision and recognizing now that Trump did win that election and now operates with that kind of near total immunity that the Supreme Court granted him last year. I'd like to just do a quick review of what's happened since January, since he took office. Just in the first week of the administration, there was a massive immigration crackdown, an abolition of federal anti-discrimination policies, a declaration of biological truth on gender. I'll come back to this later regarding one of the merits decisions that was issued late in just last month in Skirmety. Unsettled the federal civil service, right? The stability of or destabilized the federal civil service, removed multiple watchdogs, what we call inspectors general, undermined security clearances, shut down foreign aid when we think about the USAID, budget cuts or closings, attacked multiple independent bodies throughout the federal government and called for drastic reductions in the federal workforce through several executive orders, including one directed at the Department of Education, which the Supreme Court just ruled on again last week. The first month, then, looking past the first week, the first month included the formation of the Doge group, the Department of Government, was it effectiveness or efficiency? I forget what the E stood for in the acronym, led by Elon Musk, who was then an ally of President Trump. But one of the crucial things that Doge did was entering these vital federal databases, including both taxpayer identification, but also all the data on the federal employees, federal workforce, without much security at all. These first few months of the administration have also dramatically undermined federal law enforcement. We think about the pardons for the January 6th insurrection. That's the January 6th insurrection is also part of this larger context, but in his first few months in office, President Trump has pardoned the January 6th, the multiple people who have been convicted for the January 6th insurrections. It's important to recall that that's more than 1,000 people, right? More than 200 people were convicted at trial in front of a judge or a jury, and then more than 1,000 other people pled guilty to crimes related to the January 6th insurrection. So we're looking at more than 1,300 people charged and convicted. All of them now pardoned. President Trump was doing this while also pushing out many of the FBI agents and prosecutors that investigated and prosecuted the January 6th offenses. Emil Bove, now an ally of President Trump himself, helped prosecute some of the January 6th offenses and now talks about how those prosecutors are bad people. Thousands of people have been fired at the FBI, and national security personnel have been reassigned. So all of this is in the spirit of the larger context of what's going on in the country as the Supreme Court is facing the cases that come before it. Returning to the immigration crackdown in the second Trump administration, since January, the Supreme Court started out with 3 rulings against Trump, right, that were effectively losses for the Trump administration. One case saying that due process is required before undocumented individuals are removed from the country. In the very high-profile case of Nomar Abrego Garcia, the Supreme Court also said that he needed to be brought back to the country, right? Sort of affirming a lower level court decision saying the same thing. It's important to note that for months the administration ignored those opinions, right, including the opinion from the High Court. And then a second case involving the American Enemies Act, where individuals need to be afforded meaningful process before removal. But since then, the court has almost uniformly issued what I would call bad decisions or wins for the Trump administration, right? Removing temporary protected status for 300,000 people in the United States, also removing humanitarian parole, another 300,000 or 400,000 people affected, and then allowing removal to third countries, right? Which in many of these cases, for humanitarian reasons or human rights reasons, the individual cannot be removed to their home country. So then the United States is removing them to third countries, but who then very clearly plan to deport that person to their home country where they would be vulnerable to violence. And then we have the birthright citizenship case that came up at the end of the term, which was not decided on the merits, but effectively said that all nationwide injunctions now from lower level federal judges are no longer okay, no longer allowed. This is a major win for the Trump administration's policies now. And the fact that it's happening now and not previously when the same issues have been raised is important. And I can come back to this later. Overall, many of these cases, especially in the immigration arena, law enforcement, the executive control over the federal government. There is a massive concentration of power in the executive branch. And if we look just at the immigration arena, again, immigration law enforcement agencies are quickly becoming the largest law enforcement and correction agencies in the country. And their budgets and personnel are supposed to expand more than threefold under the BBB, the Big Beautiful Bill, right? So the ICE and its immigration enforcement agencies will become the largest federal law enforcement agency. And the budget of the detention center, the immigration detention centers, is going to be larger than the budget of the Federal Bureau of Prisons. So that's ICE and its detention facilities are quickly becoming the largest law enforcement agency in the country and the largest custody detention agency institution in the country. So many of these decisions here are cases, the ones that I've mentioned about immigration are cases that have come up on the Supreme Court's emergency docket, right? But especially the birthright citizenship case allowing or saying that the lower level nationwide injunctions that were blocking the administration's actions in these areas, the Supreme Court, by saying that those blocks are not okay, is green lighting many of the Trump administration's policies. I'm not going to spend a lot of time talking about the emergency docket because Professor Novkov is going to go into greater detail about those cases. But I just wanted to highlight that those cases are coming up on this separate emergency docket, or what some people refer to as the shadow docket, because those cases are not fully argued and the court tends not to explain its reasoning in those decisions. But I won't say more about those cases. I did want to say just a couple of things in the middle of this about some of the major merits cases, or cases that arose on the merits docket, the major substantive cases that the cases that the court has heard this last term. One that I mentioned earlier about the administration's, the Trump administration's declaration that about the biological truth of gender comes back to a major case on the court's merits docket, U.S. versus Skermeti. In that case, the Supreme Court upheld a Tennessee ban on certain medical treatments for transgender minors. This decision, this majority decision, is a real blow for transgender rights. In doing so, the majority kind of tied itself into knots because it said that its decision did not turn on sex, but rather on the medical purpose of the treatments. That is, it seemed to be saying that it was okay for doctors to administer puberty blockers to minors of any sex for certain purposes, but not for what it called, quote, gender dysphoria, gender identity disorder, or gender incongruence, close quote. This seemed like an avoidance of the heart of the issue and is difficult to interpret other than as discrimination based on gender, or a statement that gender is a clear biological concept that states can now regulate. Essentially taking the administration's side on one of these early statements from week one of the Trump administration. It's hard to know what this means for an earlier case, Bostock from 2020, in which the majority ruled that gender discrimination in the workplace is sex discrimination. So this is one of the challenges that lawyers, policymakers, people in government are going to have to deal with, and the courts are going to have to deal with. And I'd be happy to come back to that more later in the discussion. In another major case, Mahmoud v. Taylor out of Maryland, this is a case out of Montgomery County in Maryland. There, a group of parents, a combination of Catholic, Muslim, and Ukrainian Orthodox parents, used the First Amendment to argue that some of the books that the school district was including in its curriculum were against their free exercise of religion. So the books in question touched on LGBT topics, and this group of parents was opposed to their children being exposed to those books. The school district argued that they were creating an inclusive curriculum and they had gone through the local district process to create this curriculum. The Supreme Court sided with the parents. So now in practice, parents will need to receive, the case stands for this proposition that parents need to receive notification about what materials kids will be exposed to in the classroom and the right of those kids to opt out of class at those times. These implications are massive of this case. Professor Jeremiah Chin at the University of Washington says the implications of this case are ridiculously broad. It's hard to think about how this will play out in practice. What will be the cost to school districts to provide this kind of notifications? Will school districts simply prune their materials themselves, sort of ex ante, of anything remotely contentious to avoid conflict, resulting in the most kind of plain vanilla curricula across the country? In the larger context related to funding, I mean, these kinds of notifications would be very costly. And this process is playing out just as the Department of Education is being decimated. That goes back to one of these emergency docket cases from last week. State budgets are already hurting and local school districts are getting less federal support. In New York, for instance, school funding was not set to return to pre-financial crisis levels, right? Pre-2010 levels until next year, 2026. And now we're facing these new budgetary and legal challenges. Also, from a governmental perspective, the case doesn't speak very highly of local control. For decades, conservative lawyers and activists have tended to focus on delegating control over these kinds of policies to local authorities. But here, the process of the local district to shape its own curriculum was completely undermined and kind of overlooked. So I think I'll stop there and turn it over to Professor Novkov, but I'm happy to come back to some of these issues in the Q&A. Thank you.
Thank you, Matt, very much. What I'm going to have to say, I think, underlines a lot of what Matt has already said. Ordinarily, when Professor Ingram and I do an event where we're talking about the Supreme Court term in retrospective, you would expect us to get on the Zoom and talk about the outcomes in the key merits cases that the court decided. So the ones for which the court considered the petition, accepted it on a grant of certiorari. There were oral arguments, the debates among the justices over majority opinions. And then at some point at a regular sitting of the court, you would get the release of a majority opinion and possibly some concurrences and dissents. This term, that is probably not the leading headline about what happened on the court this year. The court did follow its usual practice with its merits docket. They ended up issuing 66 opinions, which is about in line with what they've been doing for the past few years under Robert's leadership. There was a continued pattern of fewer unanimous rulings, but a good number of them. It was about 42%. And only about 15% of the rulings on the merit docket were 6-3, and 9% of those had the three liberals in dissent, 6% had Thomas Alito and Gorsuch in dissent. And overall, the liberals were in dissent about 15% of the cases. However, when you're looking at the term on the whole in retrospective, you have to include what happened on the emergency docket this year. It has become, as scholar Steve Blodek has pointed out, an increasingly important part of what the court is doing. And this may be the year where I think we could say that the emergency docket is really the most important part of what the court has been doing this year. Depending on how you count, they considered around 113 cases. Some of them were consolidated appeals. 61 of these cases were handled prior to Inauguration Day. And I think we can see a pretty sharp divide in the court's behavior if we look at pre-inauguration emergency docket cases and then post-inauguration emergency docket cases. While Biden was still the president, the court denied most of these petitions. It was an election year, so there were some attempts to get emergency intervention into election litigation. There were 2 instances in which the court lifted injunctions against state laws that were seeking to remove voters from voting rolls, but the rest of them were rejected. The court also rejected a number of cases where individuals were trying to stop regulations that the Biden administration had put forward, particularly EPA, on an emergency basis while litigation was playing out. However, Biden did have some significant losses on the emergency docket. The Eighth Circuit put an injunction in place barring the Department of Education from implementing a rule that would protect trans individuals in educational environments. The court lifted that injunction and left it in place. The court left that injunction against the rule in place. Likewise, there was an injunction against an attempt by the Biden administration to implement student loan relief through the SAVE Act, and that injunction was left in place. And then I just want to note that there was a specific challenge to a national injunction put in place against the 2021 Corporate Transparency Act. Not a case that got a lot of attention, but the challenge was to a district court's judge having put an injunction in place that stopped this legislation from going into effect nationwide, and the Supreme Court let that go through. They did not respond by granting relief to the administration in that case. If we look at what happened after Inauguration Day, some of it was business as usual. The Supreme Court did things like continuing to deny relief to individuals on death row who were raising various objections. They continued to deny relief in a number of individual criminal cases as well. But what was uncharacteristic was the wave of litigation launched against the Trump administration and its operatives, and the ways in which the Supreme Court acted as a brake against this litigation. Political scientist Adam Bonica has gone through and collected the cases that have been filed against the Trump administration, and he found that if you look at a period between May 1st and June 23rd, nearly 95% of the cases filed against Trump were resolved in a preliminary fashion against the administration. In other words, the district court judges hearing those cases thought that what was going on was problematic enough that it was worth pausing those operations while the litigation played out to address the deeper questions in the case. In the same time frame, when the administration challenged these injunctions before the Supreme Court, they went 15 for 16. So this was a really remarkable grant rate. Overall, since Inauguration Day, the court has handled 20 cases on its emergency docket that have addressed policies of the Trump administration, and 16 of those cases have provided at least partial relief to the administration. As Matt mentioned, with these emergency docket cases, the court frequently doesn't explain its reasoning. Sometimes they're even being decided in the form of just a very short order that either denies relief most of the time or occasionally would grant relief. But another interesting factor about the emergency docket this year is that we're seeing a very divided court. This is not just an instance where, like back in the 70s, Justice Marshall would often object to the court's refusal to take up death penalty cases. This is much more systematic and covering a number of different areas of law. In these 20 cases where the court was considering something about Trump administration policies, in only 2 of them was there no objection whatsoever or no comment about what had happened. So in 16 of them, at least one of the liberal justices registered some disagreement with some aspect of what had happened in the case. In 8 of those cases, you had all 3 liberal justices objecting. 4 of them, an additional 4 had Sotomayor and Jackson objecting. There were 2 where only Justice Jackson objected. And there were actually 2 cases where you had the 3 liberal justices plus one of the conservatives. Matt has already gone through several of the substantive outcomes that we've seen. What I want to underline here, though, is none of these rulings are final decisions about the merits of the case. So the court was not deciding the ultimate legitimacy of whether the Trump administration can remove temporary protective status or terminate humanitarian parole or allow DOJ to get access to all of personal confidential information in the Social Security Administration's databases, et cetera. More, they are about what should happen while litigation is going on. And the general standard for this is, what is the risk? What is the potential harm to litigants who are objecting to a government policy versus the damage to the government if it is not able to implement the policies that it wants? And if the judge believes that a policy looks like it's more likely than not, at the end of the day, not to survive judicial review, and it could generate some real harm for the people involved in the implementation of policy, the judge is going to put first a temporary restraining order and then a temporary injunction in place, basically to pause the operation of that policy until the case can play its way out and the courts can reach a final determination on whether or not this policy is okay under law and under the Constitution. And what we've seen repeatedly is district court judges taking a look at these policies and saying, yeah, it really doesn't look like this comports with our legal standards, violates congressional laws, possibly violates the Constitution. And if these policies are put into place, they're going to do real harm to the people who will be subjected to them. So better to pause them while the litigation is playing out. And then if it turns out everything's okay, they can go ahead and be implemented. The Supreme Court's take on this has kind of been in the opposite direction. They have allowed these policies to go into place, and their stance has been, well, let's just see how it plays out once these things are implemented. And then if it turns out in the implementation that they are violating congressional laws like the Administrative Procedure Act or the statutory apparatus that regulates immigration, then we will intervene at that point once we show that there's been somebody who's had a concrete injury as a result of a violation of the law or the Constitution. So what are we waiting to see? Again, can the government strip temporary protective status, terminate humanitarian parole, allow the Alien Enemies Act to be used as a basis for summary deportation, even with minimal process? The court has said, let's wait and see with mass terminations of federal employees. Let's wait and see how the government goes about dismantling the Department of Education. Let's see what happens if the Trump administration fires individuals who are working at independent government agencies. And let's see what happens if the Trump administration moves forward with removing individuals with gender dysphoria from the military and goes ahead and implements its refusal to recognize certain forms of birthright citizenship. So that's kind of the situation that we're in right now, and we'll wait to see what happens as this litigation plays out. What we're seeing now is this kind of cat and mouse game evolving between not the Trump administration and the courts, but the lower federal courts and the Supreme Court. So individual district court judges have sort of gone back dutifully, and they've been doing the kind of fact finding that the court has demanded. And we're seeing them put into place narrower kinds of hurdles for the Trump administration. So, for example, in the birthright citizenship litigation, the court said, no, you can't do universal injunctions. That's really problematic. So the district court judge who was involved in one of those cases turned around and said, well, I'm certifying a class of individuals who are born under circumstances that would potentially subject them to this executive order. And I'm enjoining the enforcement of the executive order with respect to these individuals nationwide. So, and we have not yet seen, how the Supreme Court will respond to this gambit, but we may go through another round of back and forth. If we kind of take a step back and just look at this, what can we conclude? I think there are a couple of lessons we can conclude. A lot of people in the legal community have tended to be pretty disparaging about the Trump administration's legal officials, objecting to the kinds of outrageous arguments they make about statutory and constitutional interpretation. But one thing they are doing, I think very effectively, is picking and choosing the cases that they want to move forward through the emergency docket. They have figured out the places where the Supreme Court is going to be willing to collaborate with them. And they have chosen the way that they framed those cases very carefully so as to encourage the court to allow the administration to go forward with what it's doing. Again, the birthright citizenship case is a great example. They had nothing to say about the merits of the constitutional question in their appeal. They simply challenged the imposition of a national injunction. And you see in the dissent in that case, Sotomayor actually calling out the majority for not digging into more of the fundamental constitutional question. So that's one lesson, that the Trump administration lawyers are selecting their cases effectively. The second is to notice the bitter divide on the court about what fundamentally is going on here. You see the majority, which is basically allowing the administration to put its policies into effect and saying, we'll take a look at them once they've been implemented and once they've gone through the ordinary process, and we can consider these things through our merits docket as kind of ordinary disputes over government action that are suitable for resolution in the ordinary flow of legal time. The dissenters, on the other hand, are really calling out the Trump administration for engaging in rampant lawlessness and defiance of the federal courts. You see a real tone of emergency coming out of the three liberal justices, particularly Justice Jackson and then Justice Sotomayor. They're very alarmed about what is going on, and more alarmed that the court seems to be empowering this kind of behavior. Then what is the majority thinking here? Certainly there are a few justices who seem to be perfectly on board with fully collaborating with the Trump administration's attempt to empower the executive branch. So you see Alito and Thomas making comments like this in the concurrences that they've had in many of these rulings and a couple of dissents on cases that went the other way. Some of this might be this kind of business as usual. Let's just wait and address cases on the merits when we have a fully developed record, and possibly we have a couple of decisions going in opposite directions in the circuit courts. That might be some of what is going on for some of the justices. But underneath this too is the possibility that Chief Justice Roberts is worried about issuing an order that the administration will ignore. We've seen the administration ignore or skate rulings that have come from the federal district courts. It may be sort of a let's just wait until we're backed into a corner and have to make a decision on the merits that might provoke defiance on the part of the Trump administration. Or if we want to be as generous as possible, the majority may simply be waiting until they have that perfect case with the perfect plaintiff, with a fully developed record where they can simply say to the Trump administration, no, this is not okay. Or they may be assuming that these cases are going to reach them on the merits docket after Trump is no longer president, when they can then step in the ordinary course of business and make some high-minded statements about the rule of law, the power of the executive branch, and the need for the court to remain the final and authoritative interpreter of the Constitution. The final point I just want to underline for folks that I didn't necessarily see coming, but has certainly been interesting to watch, is that to the extent we can still consider the court to be a juristocracy, to consider it as a very empowered institution that is interested in grasping more power, they seem to be playing this card not against the other institutional branches of government right now, but against the lower federal courts. You see Justice Kavanaugh in his concurrence in the birthright citizenship case talking about the need for the court to be the final determiner of what the game is going to be on the ground as all of this stuff is working its way through the legal process. So what that suggests to me is that we are going to have to continue to keep a close eye on the emergency docket going forward, because it is going to continue to be a very busy space where we are going to see national policy being made and being supported by the justices in the majority. So with that, I'm going to stop, and we will now do our best to answer questions that you may have. Okay, the court may be waiting for Trump to be out of office. Is there a historical precedent for that kind of playing with the calendar? Is that a real consideration in this hyper-partisan period? And we can go back to the Civil War, when the court kind of waited until some of the crisis was over to issue rulings that then less worried would achieve compliance. Is that a real consideration in this hyper-partisan period? Well, in a way, it might be the best of both worlds for this court. We've seen that it is a very conservative court, and as Matt and I have both observed, the justices have tended to be more willing to impose limits on Democratic presidents and Democratic administrations. So if they were to wait until cases reach fruition on the merits, and they are making those decisions at a point after Trump, if there is a Democratic president in office, even if the legal principle that resolves a case is looking backward to something that happened during the Trump administration, it would obviously have an impact on the power that a Democratic chief executive would be able to exercise. And again, it can take a while for cases to reach the court on the merits, and they do have control over this process. They don't necessarily have to accept cases for review immediately, so they can structure this. I can't believe we've explained everything so well that nobody has any further questions. Will this very conservative court ultimately greatly expand the executive power of the president? I think that's a great question. Well, why don't you take it first, Matt?
Thank you, Julie. I was just gonna share I was gonna share something, but I don't have powers to share. But just I was gonna share an image. Maybe I could put it in the chat. Is it okay to share it? That complements what Julie was just saying. Can everybody see it now? This is an image of the Supreme Court's behavior with regards to these cases on the shadow docket or the emergency docket that Julie was just talking about. On the left, you can see the court's behavior with regards to the Biden administration. On the right, you can see the court's behavior with regards to the Trump administration. In simple terms, green means the court is behaving favorably, right? It's kind of helping out that administration, and red means that it's blocking that administration. And so you can quickly see visually what the Supreme Court is doing in terms of its behavior. It's in a quite literal way, it's green lighting many of the executive policies under the Trump administration when it was blocking those policies under the Biden administration. So to answer the question, again, it's a great question. Traditionally, you would think that a conservative court would not be in favor of expanding executive authority. But in very real terms, visually, you can see that it is expanding executive authority. Right? It's allowing most of the executive policies under the Trump administration to go forward in a way that it was not doing so with the previous administration. And maybe just to build on that and go back to touch on the larger context that I was talking about earlier. Julie was noting how courts tend to evaluate these applications for stays, right? And they go through a balancing of harms and equities and a likelihood to succeed on the merits. And on many of these cases, the way the court is, in many cases, they're not offering any explanation, but in some of the cases where they have offered explanations, the way they're thinking about the harms is in a very narrow way, right? For instance, in the case where the members of the National Labor Relations Board and the Merit Service Protection Board were fired by President Trump. Those removals are only supposed to be done for cause. But the administration did not provide any reasons for them, just fired them. And the way the court thought about that is like in balancing the executive power of the presidency versus the interests of these two people in the interests of two people in their jobs. There's greater harm to the executive branch, right, to the executive power than to these two individuals and their property interests in their individual jobs, right? That's a very, very narrow way of thinking about the harms in doing this, right? The reason why those two people's jobs or all of the people's jobs on these independent bodies are protected is to prevent the expansion of executive authority, right? And to provide for a more efficient, accountable way of doing government. So really the harm is to the nature of democracy, right? And to the separation of powers and to the effectiveness of government, and to not allow the executive branch to intrude too much in certain independent bodies where you want them to behave, you want them to be less vulnerable to political interference. That's the broader picture, right? That's the broader harm. So in a way, the court is greenlighting executive authority, expanding authority, returning to the question, but also in the way it's explaining itself, it's thinking very narrowly about harms and seems to be very dismissive about the potential harms to democracy and the rule of law.
Thanks. Got a bunch of questions in the chat, so let's see what we can do. Professor Acker asks, with Congress as compliant as it has been and the Supreme Court acting as we've described, is the fundamental assumption about centrality of separation of powers at risk? Well, if you have a collapse of checks and balances, that's going to make it quite difficult for separation of powers to operate effectively if one branch wants to aggregate to itself the functions and operations of the other branches, and they're not getting significant pushback. So I would say simply, yes, this is a concern. To Renee's question about the CASA case, the judges that have considered this question on merits have concluded that the EO is a clear violation of the Constitution. So why do we get that outcome at the US Supreme Court? I think we will have to wait and see what happens. The court basically took this opportunity just to take a swipe at nationwide injunctions. I suspect that this is in part about the CASA case itself, and then suggesting that they should go through the more onerous process of certifying a class and proceeding through a class action. But it is also a warning to the lower courts to be careful about issuing really broad injunctions. They are going to have to figure out ways to justify what they're doing. You see the Supreme Court also making some comments here and there about standing of individuals who are bringing these challenges against the administration. So again, it does seem like the court is taking a position of holding off on considering these questions on the merits, even when it does seem like there are some very clear answers to some of them. Have we been here before? I don't know, Matt, you might have thoughts about this. I guess I would say the closest analogy I can come up with, thinking about the national picture broadly and not just the Supreme Court, is the Gilded Age, when we did have some very problematic political developments where a lot of people were feeling like individuals who were in positions of government authority were largely in it for their own personal gain. And you had a court that was allowing a lot of bad things to happen, reinterpreting constitutional provisions to gut any form of racial equality and to empower corporations. But I do think there's something somewhat different going on here because of the extreme level of empowerment that we are seeing for the executive branch at a moment when the courts are also very, very empowered. So it is, I don't think it's just sort of a constitutional cycle. We've seen this before. Eventually the wheel will turn. It is, there are some very distinctive elements to what's happening. So any of these you want to tackle quickly, Matt?
Well, one, I just wanted to say that the court is choosing to empower the executive at this point in time, right? They could have chosen to do so earlier. Say the Biden administration, when they were asking to move forward on their own preferred policies, right? And they chose not to. They're choosing to do so now with this administration, despite the previous context, right? And building on the immunity decision from last year, and neglecting a lot of the history, right? So they're choosing to empower and expand the authority of this administration. And there's another question there about Fed Chair Powell. That's one of these independent bodies, right? The Federal Reserve is one of these independent bodies, like the NLRB or the Merit Service Protection Board. And for a variety of reasons, many people, even on the Republican side, have been encouraging President Trump not to touch the Federal Reserve, right? That's somehow different. But technically, there's nothing different about the Federal Reserve and the National Labor Relations Board, the Merit Service Protection Board, right? He's already kind of very arbitrarily removed members of those other boards. So he could do the same. That's not consistent with the court's jurisprudence, right? There's sort of general agreement that that's not what the precedent stands for. So he should have lost on these emergency docket cases, right, on the likelihood to succeed on the merits, and then with a broader view of what the harms are. But there's nothing different about the removal of Powell versus the removal of some of the other members.
Yeah, just a quick note on the emergency docket more generally. The court receives thousands of petitions on the emergency docket every year. Many of them are coming in relation to individual criminal appeals. But what we have been seeing in the last few years is the court taking more of these cases on their emergency docket, which they can simply choose to do or not. And then taking cases that have implications for more than just the individual plaintiff who's involved. Steve Vladeck would say that this sort of goes back to Douglas's attempt to take up a petition to stop the secret bombing of Cambodia during the Vietnam War. But over the last few years, we've really seen an expansion in the use of the emergency docket to handle cases that have national significance. And a number of legal scholars have expressed concern about this. In terms of checking the president, the major precedents involving checking presidents and exerting presidential oversight do go back to Watergate. But a few other cases that have addressed these kinds of questions have happened since Watergate, but really Watergate is the touchstone for thinking about checking executive power and ensuring oversight. Although we should note that certainly the Biden administration experienced some limits on the exercise of executive power, sometimes through the emergency docket. Is Amy Coney Barrett going on an independent course? Probably a little too early to say, but certainly with the emergency docket cases, she was standing with the conservatives. So I wouldn't make too much of the narrative that, oh, if you look at her behavior in the merits cases, it seems like she's shifting more toward the middle. She's certainly not Gorsuch or Alito or Thomas, but the idea that she's going to become Justice Souter, not seeing it. Last question, would I pick one to close us out, Matt?
I was also going to say something about Justice Barrett or Coney Barrett. I mean, she authored the explanation that was provided in the CASA case, the Trump v. CASA case on birthright citizenship. So that's not a good sign of a more moderate or independent course. I think that case on the likelihood to succeed alone should have gone against the Trump administration. But then also on the balance of harms. I'll stop there.
Well, we are out of time. I would just say if you are interested in what is going on in the federal judiciary, the justices are not necessarily going to listen to your letters and petitions. That's not how they operate, but you can and should pay attention to the people who are being nominated to serve on the federal courts and reach out to your elected officials to express your opinions about the people who will potentially be joining the federal bench, because this very, very much matters. So thank you all for spending your lunchtime with us. I hope we've been helpful to you.